what we're presenting today, the issue at hand is really the governance framework for biodiversity conservation and use. And how we're going to present is I'm going to do a first part, essentially presenting the policy scenario in which we're going to make theoretical proposals, which Vicki will do in the second part, that should have also policy implications. So I'm going to go ahead and start just some basic terminology because it can be a bit technical. Sorry for this kind of middle school diagram here, but it helps to understand. When we talk about biodiversity, we talk about 3 levels of diversity: ecosystems, species, and genes. And today what we're really talking about is the essentially genetic diversity is the one that we're going to talk about most. So when we talk about genetic diversity, we mainly refer to genetic resources. This is the terminology in the Convention on Biological Diversity, the Framework Convention from 1992. And what's central to understanding genetic resources is this concept of value. As you can see, they define genetic resources by the value that they potentially have or have. And just to exemplify, I have a picture here. These are rice varieties. So this is an example of the genetic diversity within rice. So this is the kind of resources that we're talking about, mainly resources that can have industrial applications. So it could be seeds, anything from an animal, genetic sequences, etc. So what we're seeing here is really reconceptualization of biodiversity as an economic resource. How did we get here? This is really a story of evolution of technology and expansion of intellectual property rights, which I'm going to refer to as IPRs, just to be a bit shorter. So we saw this extension. It really started already in the 1960s with plant variety patents, essentially. And then this movement of extension of IPRs to living organisms or these kinds of biotech products derived from them, I think it's fair to say they were solidified with 2 decisions. Diamond versus Chakrabarty is a US Supreme Court decision from 1980 that validated a patent on a genetically modified bacterium. And after that, we saw a huge increase in biotech patents. And then you have the TRIPS agreement from 1995, which has that Article 27.3b, that it allows for exceptions on patenting genetic material, but it does not explicitly exclude biological genetic material from patentability. So what we have is that biotech allows for lucrative use of genetic resources and associated traditional knowledge. There's no internationally agreed upon definition of traditional knowledge. I have a definition here from WIPO, the World Intellectual Property Organization, which is kind of a placeholder we can use. But the concept of TK essentially means that there could be certain products. Let's say I use the example of stevia, which is very illustrative, which is a plant that is used by the Guarani people in Paraguay and Brazil to sweeten food and drink. So from the perspective of, let's say, indigenous traditional peoples, the argument is that if companies didn't have this knowledge to base innovation on, they wouldn't be able to get to that innovation. So traditional knowledge needs to be taken into account when thinking of how resources and knowledge are used for innovation and kind of mechanisms of compensation. And we're going to get into that. So when we talk about use of GR and TK, we're talking mainly of pharmaceuticals, so drugs, like pharmaceutical drugs, plant-based cosmetics, and these agri-food products like Coca-Cola, stevia sweetened Coca-Cola. So the governance framework for all of this is essentially the Convention on Biological Diversity, which I'm going to refer to as the CBD, signed at the Rio Earth Summit in 1992. And this is where we see a pretty solidified transition from biodiversity being kind of part of this global commons to being subject to private property and especially national sovereignty. The CBD has 3 main goals: conservation of biodiversity, sustainable use of its components, and this third one is what we're really going to focus on, the fair and equitable sharing of benefits arising from the use of genetic resources. And this third goal was further reinforced with the Nagoya Protocol in 2010. I'll get to that later. And the CBD is very much a result of North-South divisions. And just quick caveat, I'm going to talk about North and South, but clearly we're not talking about these huge homogenous groups. We need to recognize the heterogeneity that we have in the global North and global South. but it is kind of an operational division that we can use, and it does manifest itself in multilateral negotiations. And why is there this north-south division when it comes to biodiversity? I have the map here that shows where the division stems from. Is essentially that you have most of the world's biodiversity hotspots are found in what we call the global south. Now, the issue is that the biotech resources, economic resources to be able to use this biodiversity, to implement these associated traditional knowledge for the purposes of innovation, that is found mainly in the global north. So the negotiations at the time were based on this idea that, let's say, the South has all the resources to support innovation, but we're not getting anything. We're not getting any benefits from these innovations, right? So the idea of the CBD is that we would do a win-win agreement. So we're going to determine that biodiversity is no longer a common heritage of mankind, right? Which was kind of the situation up until then. We're going to submit biodiversity, biological resources in general, to the national sovereignty of the states. So each country can determine how others will access their resources and use those resources. They can allow access or they can restrict access as their national legislation permits. And why did we get here? Like I said, the issue is that up until then, they saw that if the resources were left in this sort of global commons, there was a risk of appropriation, in the sense that if anybody can come in here and access our resources without asking our permission, we're being pillaged. This was kind of the thinking at the time. And that idea of pillaging was kind of transformed into the concept of what we call biopiracy, which was coined, it's a term coined by an NGO in about 1992-93, just after the CBD. And the CBD would essentially kind of be a solution to biopiracy. And that by creating value on genetic resources and TK through IPRs, not only would we, and creating this national sovereignty, not only would we protect the resources of these countries of the global south, we would also create value on them that would allow for benefits to be shared. So it's really through patent rights on these products derived from biological and genetic resources that we can create economic value that can be shared with the countries of the global south. And this culminates in this mechanism of access and benefit sharing, which I'm going to refer to as ABS, established with the CBD and later reinforced with the Nagoya Protocol. And ABS is really, it's a norm. It's also kind of a functional mechanism to realize that third goal of the CBD of fair and equitable benefit sharing arising from the use of genetic resources. And it's very much in this utilitarian logic of, if we create value, right, that's going to incite the countries and communities of the South especially to conserve their resources. Because if we conserve, we can allow access to our resources to firms and research institutions of the global north. And when they establish, let's say, what we call ABS agreements with us in the global south, we'll be able to share the benefits of whatever products arise from the use of resources. So this was mainly put in place through what are called bioprospecting agreements. So essentially, let's say a research institution from the United States enters in an agreement with a university in Brazil that's also maybe involving indigenous communities that have certain resources on their land. And so they all join in this ABS or bioprospecting agreement, in which if the university or the firm involved creates a pharmaceutical product from that research agreement, the firm can have patent rights on the product, but then they'll share the benefits of that commercialization with the indigenous community and let's say the university or whatever other government institution is involved in the agreement, right? So this is supposed to prevent biopiracy, and that users of genetic resources or traditional knowledge will have to seek the prior informed consent of those provider countries or communities. And it's all based on IPRs, right? If you don't have IPRs in order to generate benefits, there's really no ABS. Now, the results of this have been very, very meager, essentially negligible impact on conservation, because also the economic benefits from ABS were supposed to not only incite conservation, but also finance conservation projects. and of course, spur economic development for indigenous communities, for countries of the South. Very little of this has happened. The impact on conservation, I think we can all agree that we're still in the middle of sixth mass extinction, so I don't think ABS agreements have put much of a dent in that. Okay, going to move on. Now, what we really want to get to is the challenge of digitalization. So what does digitalization have to do with this policy scenario? First of all, just to define some terms, what we're talking about here, when I say digital sequence information, or DSI, it's essentially digitized genetic sequence data. DSI is not a consensual term in the scientific community, but it's a placeholder term that's being used in the CBD and Nagoya policy debate, so we're going to use that. And it's essentially genetic resources in digital form. And these are, this is information data that is largely accessible in open access on online public data banks. So I put here the example, it's the SARS-CoV-2 genome that was sequenced very quickly last January. And I got this from the NIH GenBank, which is a public access data bank. And this kind of data is really crucial for research and innovation. We can just look at the COVID-19 vaccines, which kind of based a lot of the work on this large open access of genome publication. But it's also crucial for knowledge about ecology, conservation, taxonomy. A lot of researchers based a lot of their work on this huge open access information. And so what we have today is a sort of a digital commons for genetic resources that we didn't have 30 years ago. So what are the policy implications for ABS? Well, what we feared of biopiracy 30, 40 years ago is now kind of resurfacing, but in digital form. So like I said, digital commons today is yesterday's common heritage of mankind. Countries and communities of the global South are now fearing digital biopiracy, and that if our resources and our information are accessible online, we just have another situation where our resources are in the commons, but this does not preclude IPRs on the results of innovation based on that publicly accessible DSI. So we're kind of recycling the same debates from 30, 40 years ago. And the problem is that CBD and Nagoya Protocol have no mechanism in place for governing this. These agreements were made on the basis of a physical access to genetic resources and associated traditional knowledge. And there's no consensus today on whether ABS and CBD even covers genetic resources in digital form. So this is why I asked this question here based on this work by Bond and Scott. Does the materiality of genetic resources matter for how they're governed? That's a big question that we have to ask. So like I said, we have a recycling of the North-South divide with opposing positions, very much similar to what we saw 30 years ago. On the one hand, the countries of the North, developed countries, argue that the CBD definition does not cover DSI, and actually open access to this online data should be maintained, because this is what encourages innovation, data sharing, and it's crucial for scientific research that could produce things that are global public goods. And this is to an extent very true. Now, they also argue for protecting IPRs once innovations are made. Developing countries, argue essentially the opposite. The CBD does or should cover DSI. ABS regulations should also govern digital genetic resources, because open access to this genetic data online is leaving our resources susceptible to biopiracy, just as in the past. So what we claim as, let's say, countries of the South is that we must protect our sovereignty, so these sort of property rights over our own resources, but loosen IPRs for innovations that result from these publicly accessible inputs in the form of digital data. So again, the COVID-19 vaccines are very emblematic of what's going on. You have one side wanting to protect patents on these innovations that were largely based on public data, and then the other saying, let's have a patent waiver so that we can have access to these innovations. And just a very quick comment on traditional indigenous peoples and their input into this. The argument is kind of the same in that they tend to argue if we maintain our traditional knowledge in public domain, right, which is kind of what some industry actors want to do, because if it's a public domain, it cannot be patented. The problem is that that leaves it susceptible to appropriation without prior informed consent, so anybody can use it. But they also tend to be opposed to the concept of private property on traditional knowledge for very, let's say, I guess, cultural, spiritual reasons. Again, big caveat there, not all traditional indigenous peoples think the same way. I'm simplifying things very much just to keep also within the time limits, but we can discuss further once we're done. But these are the main issues, and I'm going to transition into Vicki's part, just kind of asking the questions that are going to underlie our theoretical proposals. Is, yeah, these policy challenges reflect kind of this enduring impasse between commons and private property, public versus private. And you can see here on the PowerPoint the questions that we're going to ask. Can we surmount this impasse between a commons where resources and information may be susceptible to biopiracy, let's say, whether physical or digital, and an IPR approach that kind of encloses these resources and information? And to what extent does digitization force us to rethink these issues? We wonder, how pertinent is the materiality, or are we just asking the same question? Are we having the same debate? Or does the fact that the resources are in digital form and information form, does this change the notions of ownership, right? Is ownership of physical goods the same as ownership of digital goods? And can getting past this help achieve the ecological and socioeconomic aims of CBD Nagoya Protocol? Because maybe it's worth thinking too that if we think about resources in digitized form, that also kind of removes the extractive aspect of the use of biological and genetic resources. So these are all things to think about. And I'll leave it over to Vicki, who will talk about our theoretical propositions.
Okay, thank you. Thank you very much, Raisa, and thank you to the organizers. I will go as quickly as possible and ask Raisa to advance the slides. So okay. I guess, so you can stay there for a moment. I guess to address the questions that Raisa just articulated, we believe that a more effective and more just global governance of biodiversity in the digital era must begin with the fundamental reconception of private property. And we think that that is vital. And therefore, our answer to one of the core questions put to us by the organizers of this conference, I won't read that, but should private property be abandoned? We answer affirmatively, yet in a qualified way. We argue that it should be, the concept of private property should be dislodged, but not abandoned. And in this position, we're drawing inspiration from Polanyi, of course, which we talk about earlier in the paper. But more specifically, we're drawing on the work of Christopher May, who has written extensively around intellectual property issues. And he insisted on this definition of property as the codification of social relations. And we also see a strong alignment or affinity with Thomas Piketty's latest work in Capital and Ideology in 2019, where he articulated property as also a notion of property, private property being converted to a notion of social and temporary property. And this definition is premised on the same idea from May and others, that property in and of itself is an embodiment of social relations. And because of that, it must be regulated and governed as such. So what we mean by dislodging rather than abandoning is shaped by this reconceptualization of property, which already begins to bring into question some of these false binaries that capitalist logic produces, namely the public-private one and the conception of private property and property rights embedded in this duality. And so as the process of digitalization, understood as the current structural transformation we're undergoing, we question the theoretical utility of jettisoning a notion of private property when the very constitution of property is unsettled, particularly for the reasons Raisa just articulated, this notion of the digital form of genetic resources, but we'll also point to whether or not personal data has been qualified as property or not. Next slide, please. So I have a quote here from Christopher May's work, and I won't read it, but it's important to underscore that Chris worked with Susan Sell on a history of intellectual property, but it's from his singular and very influential work on the global political economy of intellectual property rights as a form of new enclosure, which we talk about throughout the paper. But this work is very important for us and pertinent to understanding the TRIPS agreement that Raisa also talked about, and the CBD and Nagoya Protocol. Even though Christopher May's main concern was not those issues related to biodiversity or even the environment. Instead, he was concerned with situating intellectual property rights within this kind of critical perspective on global political economy. To reveal how the commodification of knowledge and knowledge-based resources, and for him, he was really focusing on examples of information and communication technologies, particularly proprietary software, and other forms of kind of knowledge-based resources. But he was concerned to show how these commodifications of knowledge concealed power relationships. So this goes to the conceptualization that we identified a moment ago as codifications of social relationships. So in other words, he's talking about how power stems from the ownership and control of particular innovations and technologies, and intellectual property's key the key role that intellectual property plays is this construction of scarcity of use, where none necessarily existed prior to a legal establishment of intellectual property as an institution or norm. And this leads to another affinity between May and Piketty. You can advance the slide, please, Raisa, which helps us to develop a theoretical proposition here, and that is that obviously both of them see property as politically and socially constructed, and therefore should not be taken as natural things or givens, but rather they should be understood, or property should be understood as ideational, or our ideas about private property should be understood as ideational forces accompanying these shifts in changing technologies that drive capitalist expansion and development. And so for Christopher May's work, he outlines these three narratives of justification that have legitimated private property, if you will. I have to be quick here, but he outlines that the first two are instrumental, which is derived from the Lockean labor theory of property. The second one, self-developmental, is derived from the more Hegelian notion, which is more about possession, and whereas in the first one, the Lockean view is, of course, grounded in natural rights. For the self-developmental narrative, it's more a legally constituted right. And so property in both of these narratives is linked to human endeavor, whereas this third one that May identifies as a functional or pragmatic narrative is the one where we see most clearly the kind of utilitarian logic and that's used to substantiate intellectual property rights. so it's much more a kind of an economic argument and a utilitarian one about the kind of efficient allocation of resources necessary for innovation. So it is kind of Benthamite, I guess, in this utilitarian sense, but it's important to highlight that Christopher May and others have pointed to the Rawlsian conception that there is in this narrative the possibility, given the time limits on patents, for example, that and this kind of the tied notion of potential public benefit, that there is therefore a concept of social justice that could be derived from this narrative, though it's still one that's quite utilitarian, and I think Raisa explained that as well. And now to come to Piketty. Piketty, of course, it's very difficult to summarize more 1,000-page book, but what's distinctive in Piketty's book, Capital and Ideology, is that he is really interested in the discourses. I mean, he's obviously concerned about persistence of inequality, but in this book, he's really concerned to show the discourses that have in some ways enabled this form of inequality to exist. So he calls these inequality regimes over history, and these ideologies that undergird those inequality systems. And he describes them as discourses that seek to naturalize inequality and that are seen as essential to maintaining these existing relations of power and property. So I have a quote there. I won't read it, but I think it is important to point out that Piketty himself is rethinking private property in this context, and he argues, as I mentioned earlier, that our kind of notion of private property in 21st century capitalism should be replaced with a more social and temporary definition, and within that articulation is actually a policy proposal. And of course, for Piketty, he's talking about labor management relations and ways in which to socialize property through more decision-making power being shared. And he gives the example, of course, of cogestion or management in the German and Nordic models, where wealth is distributed differently because of the presence of labor at the table. But he says that should be extended. And of course, he is a proponent of more progressive taxation. And he asserts that everyone in society should have access to property ownership. So again, there, he's not abandoning the notion of private property, but just reformulating it. So I think I should stop there, but we can come back to a discussion of Piketty's work in the Q&A if you'd like. And then if you would advance, please, to the next slide. So how does these narratives of justification accompanying our understanding of property, and particularly as intellectual property relates to this question of biodiversity? How do we use these ideas in May and Piketty's work to develop our own theoretical propositions and to overcome these binaries that are causing really the stalemate? And so we look at the centrality of data and the very fact that at this particular moment in structural transformation, with intensifying digitalization of everything and of course the accompanying commodification that has to take place as well. So we quickly run through the different eras of structural transformation and the commodifications and justifications of each one. Piketty does this too, much more extensively. But basically, we note those commodifications that have taken place with each structural transformation from feudalism to our current fourth industrial revolution. And here I would like to define quickly the fourth industrial revolution. The coin, I guess the term was coined by Schwab of the World Economic Forum, and I'll just read a quick definition. It represents a fundamental change in the way we live, work, and relate to one another. It is a new chapter in human development enabled by technological advances commensurate with those in the previous industrial revolutions. And these advances are merging the physical, digital, and biological worlds in ways that create both huge promise, but also potential peril. So it's the speed, the breadth, and the depth of this revolution that is forcing us to rethink how countries develop, how organizations create value, and even what it means to be human. And so that's kind of the understanding of where we are in this digital transformation. And it's important to point out that the technologies driving this are artificial intelligence, machine learning, quantum computing, the Internet of Things. And all of those technologies are forcing this question of what we identify here, although we didn't put it in the paper, it came up as I was preparing the slides, the nature of data.
It's time to go to the conclusions if we want to have a bit of time for the debate, okay?
Okay. So the nature of data and the data of nature. And we point to the lessons from the European Union's General Data Protection Regulation, and which of course is all about personal data. And so you might ask why personal data could have any bearing or similarities to the debate about digital genetic resources, but we argue that in fact it does. And what's important in this is that the European Union chose to not view personal data as personal property or private property, but rather something to be protected. Individuals express their personalities as data subjects, and this is a fundamental right. Personal data protection is considered a fundamental right, protected and enshrined in the Charter of Fundamental Rights. So we ask if this, and I'll wrap this up, could this rights emphasis that grounded the GDPR, and which of course has become the gold standard globally for access to data, could we apply some of the lessons learned from that legislation and the reach that it's had to understanding digital assets of genetic resources and traditional knowledge? And if you'll just go to the last slide, Raisa, I'll wrap up. And so we think that this offers a potential in a policy pragmatic way of breaking out of this stalemate of the commons versus IPRs. So I have a quote here from Chris May, I won't read, and just a graph that illustrates blockchain technology. So we're not arguing for a techno-libertarian solution, but others who study biodiversity and who are concerned about the ineptitude really of the Nagoya Protocol have suggested that this blockchain technology could be a way to trace and track and assign value to digital genetic resources. So we think that it requires further investigation, but we think there is both a new narrative and a potential technological solution. And what we suggest at the conclusion of our paper is that this new narrative would enlist both rights discourses as the GDPR and also a fairer conception of ownership, such as Piketty's notion, and that could actually move us out of this current ABS conundrum and lead to a more just and sustainable outcome for the Global South and for the sake of the planet. Thank you. Sorry, I went a little bit long.
Thank you.
Okay. Right, thank you very much. So we know, well, we can take, I think, questions for something like 10 minutes. If you have a question, please raise the yellow hand. You will find it next to the three dots on the top right of your screen. You can use that to raise a hand. And we can first go with the room, since I don't see any hand for the moment. Is there any question? No. Michel, yeah, you can just speak like this. That's wonderful.
Okay, thank you very much for the presentation. I had a question regarding the slide you had on the narrative of justification of private property. So you explained we can go for a Lockean, a Hegelian, or a utilitarian and Rawlsian justification of private property. And I was just wondering how you conciliate the utilitarian and the Rawlsian picture on private property, because I would imagine from a utilitarian perspective, the justification of property right would be more something like maximization of utility, whether utility is understood as well-being or wealth or something else, whereas from a Rawlsian perspective, property rights would be more protected from the perspective of protecting individual rights, especially from the perspective of the first principle of justice. So I was just wondering how you conciliate both approaches, since the whole point of Rawls's approach of justice is to give something like an alternative picture of justice than the one proposed by utilitarianism.
Yeah. Okay. So I think I should attempt to answer that. Well, first I have to thank you for the question, but I have to say that it's embedded in Christopher May's explanation of this third justification, and so it is utilitarian, but because of the nature of patents having the possibility of stimulating the development of research and innovation, and that can then benefit the least advantaged in society. So these are not, this is not my interpretation of a Rawlsian read on this, but Christopher May's, and he cites some others as well, that this intellectual property right and the justification that's more utilitarian in nature, where the Rawlsian kind of social justice spin plays out, is that it may not seem initially fair that only the global north, for example, or the rich benefit, but eventually these patents will produce a social good or a benefit. So that's kind of where there is this kind of logic of the scientific research and innovation will produce a public good, but it's a question of temporal, right? It's not immediately beneficial to the public or to greater numbers, but in the long run, that's the kind of social equity part that patents and IPRs can deliver.
Okay, thank you.
Well, we have a question from Stuart White. I see SW. Stuart, you can go on.
Hi there. Yes, thank you. That was really interesting, and I learned a lot. Just two quick thoughts that I wanted to share. One is, it seems to me that there's a famous essay by Anthony Honore called Ownership, which argues that the right to private property actually has kind of 11 separate components of what he calls incidents of private ownership. And I think that essay is really useful for thinking about how there are kind of multiple conceptions of private property depending on which of the 11 rights you kind of choose to go with. We're not necessarily restricted to what he calls full liberal ownership, where we have all 11 incidents. So that essay, if you haven't already looked at it, I think might be very useful. And then the second thought I had was whether there's any mileage in coming at the question of overcoming the binary from the other side, as it were. In other words, are there different ways of thinking about what a commons is? So conceptually, there's one idea of a commons where people can just kind of walk in and use stuff as they like, but there's also a notion of joint ownership, that we all own it, so anybody who wants to use it has to get the permission of all the other owners, and that permission might come with various kind of conditions. so yeah, can we come at the overcoming the binary from the commons as well as from private property?
Thank you.
Maybe I'll just I wanted to thank you for your comments. That's very interesting. Maybe I can comment on the second issue of conceptualizing the commons in a different way. I think that sounds to me like it could be feasible, but at the same time, wonder if just from a practical standpoint and implementing these kinds of policies, the idea of getting permission from everybody else in order to use certain things, I think maybe that's what blocks this from going further as a reconceptualization of the commons. I'm thinking about it from a very concrete policy standpoint, and if we want to implement ABS in that kind of way, just how do you do it? Because already, tracing access and use of genetic resources and just asking, permission to one provider, be it one country or one indigenous community, is so difficult, and it's so easy to surpass that that way of reconceptualizing may be difficult. And unfortunately, what we've seen with ABS too is just kind of a race to the bottom, in which if you want to use these kinds of resources, kind of like with tax policy, you go to the country that has no regulations. So I would like to think of it that way, though, and reconceptualizing, that this was part of the idea of the common heritage of mankind, that the idea is that we all can have access to this, but we all kind of are stewards of biodiversity, of the knowledge that comes with it in some way, and we all should kind of share in the conservation of this common heritage. But in practice, unfortunately, it just doesn't happen that way. But I do like the idea of reconceptualizing in that way, though. Vicki, I'll turn it over to you.
Okay, thank you. Yes, Stuart, I appreciate those suggestions, and I guess I would just come back to tack on one other thing in addition to what Raisa was saying, and I think this reconceptualization is important because there's this irony or contradiction in that indigenous communities, or many indigenous communities, never accepted the notion of private property to begin with, right? It's only to accommodate and to amend for past exploitation, right, and no compensation. And so I think that's why we're proposing somewhat of a hybrid and using this rights-based discourse or approach, as opposed to a strictly like market-based commodification of data approach. And this would conceive of indigenous knowledge around genetic resources, even in its digital form, as something worthy of monetary benefit, yet distinct from a more conventional commodities, if you will. So it would entail both a notion of digital property rights, as well as rights per se to protect and preserve biodiversity related traditional knowledge. But there's more to say about that, and I think we try to develop that. So I'd be very pleased to get your comments, Stuart and others. Thank you.
Yes, same here. I echo Vicki's statement.
Thanks a lot. I think we still have time for a very final round of short questions, if there are some. So please raise your hand in the virtual audience. And here, if someone, yeah, short. And then afterwards, I also have a few comments. And I think afterwards, you can answer all the questions together.
Okay, great. Thank you very much for the paper. This is just a clarificatory question, I suppose, about the nature of the problem that you're addressing when it comes to the digitization of genetic resources. So it was clear to me why there's a kind of problem of perhaps exploitation, where you have genetic resources concentrated in the global south, but you have sort of the capacity to benefit from those resources concentrated primarily in the global north. And yeah, then you have kind of problems of overuse and exploitation and so on. It wasn't entirely clear to me how the problem, I suppose, of what you call biopiracy arises in the digital case. So maybe I just wanted to If you could just clarify that a little bit for me, thanks.
And so maybe I see there are no other hands. So maybe just as a follow-up on your question, I think if you could also maybe clarify the problems that will rise with the question of enforcement. Because even when you have a common, you still need some rules and some enforcement of the rules somehow. And here the question is that it's really worldwide somehow, and it's kind of like world common somehow. And so how can we even think of some kind of, well, isn't there some kind of necessary problem of enforcement, since with this kind of global common, but no global authority to enforce the rules that would go with the common somehow? And just a very short note on the fact that you might even, well, you might find some unexpected support in the legal justification of property, because well, in John Stuart Mill's interpretation, because well, it really sounds like, you know, John Stuart Mill said, well, private property is based on the produce of labor, blah blah blah. But afterwards, he said, yeah, but this does not apply at all to the land, because no man made the land, and the argument is quite straightforward, simple, very easily understandable, and he could also apply, saying, well, this could be a problem because no man, no one created any kind of genetic resource or something like that, especially in the case of digital commons somehow, that are really intangible and not created by labor or something like that. So that might also be some kind of support. Well, if you...
Okay, I think I'll tackle the first question to clarify the issue of digital biopiracy. So essentially what's at issue here is that if we look at ABS, the whole point of ABS is that anybody who wants to access genetic resources, I'm going to keep using Brazil as an example because that's where I did some of my research. So if you want to access resources from the Amazon in a physical way, let's say go to Brazil, collect material and use that to do research or produce new products. ABS means that the researcher, the firm that wants to do that, has to have the prior informed consent of either the Brazilian government or the indigenous community on which the resources are located. And so there's a whole process to make that happen. You have to have agreements in place, etc. What happens when these, let's say the sequences of that same resource, if the sequences are digitalized, right, and in open access online, there's really no way to control who accesses that information and how they use it. So this is why these countries fear what they call digital biopiracy, because there is no, I mean, what Eric mentioned, there's no way to enforce ABS for digital access to these resources. Because what you can do today, because of advances in technology, you can very well just access a digital sequence online and use that to kind of do the same things that you would have done with physical resources 20, 30 years ago. Now we can synthesize living organisms, basically, from using data that's available online publicly. So this is the problem, and it really is an enforcement issue. And because the CBD was conceived, 30 years ago when none of this really existed, even though the practice of publishing publishing genetic sequences in journals and things like that already existed, but you did not have this infinite amount of information online, and just how do you track that? So the fact that these genetic resources are available publicly in digitized form means that there's no way to track who is accessing them, how they're being used, what they're doing with it. So that's the fear of digital biopiracy. They say, our resources are online. Anybody can use these to make new products. You can get a sequence online, make a new product, make a ton of money on that. Our country, who hosts these resources in physical form, is not going to get any benefit. So I hope that clarifies the issue a little bit. Yeah. Okay. Vicki, I'll let you maybe answer the other comment.
Okay, I'm not sure if I have enough time, Eric, to fully address your question. I think it was you, Eric, about kind of enforcement and the rules and regulations. I'm sorry, I have an echo. I'm not sure if you all do, but I guess this is actually where the combination of kind of a narrative around rights and not just, you know, kind of conceptualizing these digital genetic resources as commodities, which should satisfy in some ways the kind of indigenous understanding of this resource, even in its digital form, and yet we have to have some application, right, in the kind of digital commons that can track, trace, and assign value. Now, blockchain technology is very complicated. I'm not a computer scientist or a technologist. And blockchain technology is not just for cryptocurrencies, right? That's the understanding that most people have. And I don't have time to go into it, and I couldn't do it justice even if I had more time. But the blockchain technology would ensure a system of trust and kind of what they call hash digital fingerprints that could actually track the way in which these digital genetic resources are being accessed and used, and that would allow some assignment of monetary benefit. So this in a way, I mean, the blockchain technology, for a lot of people, it's a way to get around government authorities. That's why there's always this kind of techno-libertarian ethos, but that's not necessarily the case, but that's kind of in the public imaginary, I think. And so what we're suggesting, and what we found to be the case, is that there are many advocates of applying this blockchain technology to digital gene banks so that rules can be put into place that would protect and award benefit to indigenous community for these digital resources. I hope that partially answers the question. Thank you.
Thank you very much. It really helps. It also really helps, I think, to see what you're proposing and how interesting it is to address the problems you're solving, you're addressing, sorry. So I'm a terrible chair. I'm already late after the first presentation, so I give the floor immediately to Tawan Manakun. So we're going to share his screen so you can see the PowerPoint. And again, so if you have questions, you can also raise your hand after the presentation. We will probably run 10 minutes of schedule in order to have a debate at least and to have some questions. Sorry for that. I'm really a terrible chair.
So how can I start my who's that? I can still use the
Yes, you should be able to.
Is it sharing?
Yeah. It's not sharing yet. No.
So okay, so we have to share it first. So we say thank you again to IT Nuffield support.
I can't find my cursor though. Where is it? There it is. There we go. Hold on a second. Good.
Okay, can everybody see the PowerPoint online? Yeah. So Tawan.
Thank you. Thank you for having me today, and also thank you to Raisa and Vicki. Very interesting presentation. What I'm going to talk about today is about the relationship between the concept of freedom and private property, and also how to link them to the problem of ecological crisis today. Oh yes, sure. I would like to start my presentation like this. I think many years ago, I once read the news and found a very interesting speech from Mr. Tony Abbott, the Australian Prime Minister during that time. What he said is that the environmental crisis today is a very important problem, but if we try to solve it in inappropriate manner, like we allow for too much government intervention, what we're going to have is the very big government and too less freedom for people in the society. And to clarify what he has in mind, I think, consciously or not, is the understanding of freedom in a negative sense. He understands freedom in terms of free choices that people could enjoy without facing obstacle from government or other people. And based on the first premise, the common agreement goes that the area of free market, the rule of private property, help to protect people's choices from interference. So we should leave it if we want to protect people's economic freedom. And finally, that leads to his conclusion on why government intervention to solve the ecological crisis would result in the reduction of people's freedom. This picture summary the idea is like we have private property on the one hand, and on the other side, we have the project of preserving the world, and they come into tension. And amidst that tension, the negative concept of freedom, siding with the idea of private property, it says that if the government would like to intervene, you need to justify yourself and justify yourself strongly, because whatever you do, that's gonna reduce people's freedom. So the main question of my paper is like, how about if we change the concept of freedom from the negative one to the Republican one, which I'm going to introduce. What the concept of freedom based on the Republican tradition going to say about the issue of private property and ecological crisis? And just for a background, here is the concept of freedom as non-domination. This is the Republican concept of freedom. Basically, the Republican concept of freedom talk about the idea of free person. It said that freedom is not a matter of free choices, as the negative concept claim, because we can have a case where people have free choices, no one interfere with him, but he's still unfree, like a slave under, for example, a slave can have a benevolent master, and the master allows him to make choices, but it's wrong to say that the slave is free. But on the other hand, we have a case where we are being interfered in our choices, but those interferences are according to our control and command, and it is wrong to say that we are unfree just because of those interferences. So basically, the Republican concept said that when we talk about freedom, it should be a matter of power relationship behind interference, not the interference per se. For my paper, I define domination as a case where some person hold the power to determine the life of others, and those others have no share of equal control over that power. And to make a person free to like offer freedom as non-domination to that person, we can do either by guaranteeing the right against that power to that person, or on the other hand, we allow that person to have equal control power over that power, like in a democratic society where we allow citizens to have equal political control. This is a definition of freedom as non-domination, and my main claim in the paper is that I argue that if we replace the concept of freedom with the Republican one, we're going to be able to accommodate and reconcile the task of preserving the world and private property together. And both of them are not really intention. It's a matter of how to strike optimal balance to maximize freedom for people. And the implication of it, I think, is that if we need both the rule of private properties and we need to preserve the world for the next generation, it's a natural conclusion that what we need to do is to deal with the internal structure of the private property, which I'm going to talk about later. But the presentation going to take the structure as follows. I already defined the concept of freedom as non-domination, and then I'm going to talk how to justify the private property based on this concept, and then how to justify the right to a non-spoilage world of next generation people based on this concept. And by combining them together, I'm going to talk about the implication in terms of the rules of private property. To start with, normally there are a lot of debate regarding the relationship between the concept of freedom, the Republican one, and the institution of private property, but let's set aside all detail and technical debate. I think there are two arguments that we can use to justify the institution based on the Republican view. First of all, we can say that the private property help to eliminate the monopoly power over the market. If we allow the state to control production and allocation of goods, there's going to be a clear case of domination, and the institution of private property return economic decision power to everyone. And at the end, production and allocation of goods in society will not be determined by any particular agent, but a combination of everyone's decision together, like an idea of demand and supply. That is the first idea, to eliminate the monopoly power. And second, I'm still working on this idea. The idea is that the private property gonna guarantee the effective ownership over necessary goods that people need to have in order to be free. Basically, the Republican tradition hold that people cannot be free if they are poor, because they're gonna have to depend on others. And in order to be free, people need to have like material sufficiency, and the rule of private ownership allow them to have effective access to those conditions of material sufficiency. It allows people to control stuff they have without having to kill or to share it with others. And on the other hand, the free market going to lead to prosperity, with bring a bigger head to everyone. And of course, this is this is not always the case of the free market. The free market can produce bad outcome in terms of consequences. They can produce poverty, they can produce monopoly power as well. But Neo-Roman Republican would say that we can prevent all those outcomes by like putting some regulations, some prohibitions on the people private activities, because none of these two arguments ask for the absolute protection over private ownership. I mean, you can adjust like the rule of private ownership in the way that could maximize freedom in this sense overall. And I think this is a justification for the institution of private property that we can have if we commit to the Republican concept of freedom. I mean, if we commit to the idea of free choices, we're going to say that private property maximizes choices, right? But now we don't talk about choices anymore. It's about domination or not, and these are two arguments for it. I would like to move to like a more complicated issue, is about how we can link the idea of freedom to the task of preserving the world condition. And to do that, I would like to start with this case. Let's say that I am living in a desert island and I can find all foods. I mean, in my home, there are technologies that could produce all food, water, and everything I want. And in front of my home, there is a beggar, a homeless person. He has no material resources at all. So I tell him that every night I'm going to put resources that I don't need, or I'm willing to give to him in front of my home, and he can have them. I think in such case, it goes by definition that my relationship between I and this homeless person is domination relationship, because I have the power to determine his life. I can, if I would like him to be happy, I could give a lot of resources to him, invite him to my home. And if I would like him to die, or like to be miserable, I can do that as well. I can even ask him to become my slave with a threat to abandon my patronage. If you don't follow my command, I will not give you anything in the night. A very clear case of domination, and start from this case, we move to another case. This is the second case. Let a little bit modify the first case, given that now it's me living with my daughter on a tiny island. The island offer all material conditions that could sustain life, me and my daughters. As a guardian, now, I mean, my daughter are still children, and they have no physical power or like enough intellectual level to take care of themselves. So I think in this case, the rule in the first case apply here as well. We know that in the future, when the daughters become adults, the living conditions of them depend on me, depend on whether I am going to spare some resources for them. If I am benevolent, I like most parents, I will save some natural resources for them. But if I'm cruel, or if I just don't care, I can waste all resources on the island. And if the first case implies domination, I think this case goes as well. We have domination relationship between me and my daughter. At least when my daughter going adult, they can blame me that their life are influenced and forced by my activities in the past. Sorry for that. And now we start from a clear case of domination. I dominate the beggar through the power to spoil all resources. And then we move to the second case that I can do that as well with my daughter. I can dominate her by wasting all resources on the island. And I think this is a case of intergenerational domination. It's an individual case. And based on these two cases, I think we can conclude. It's not that different from the second case. We can conclude that current generation people as a group dominate children of the next generation. They hold the same power to destroy all resources in the world. I mean, like I have India on the island. And some might say at this point that there are one significant difference between the second case and the third case. In the second case, I hold the full power to waste all resources on this island, but in the third case, no individual holds such power. Ecological crisis is a collective problem, and I mean, one individual cannot make so much difference to the world condition. So if the domination charge links to the power to determine world condition, people of today's generation, each of them could execute themselves on the ground that they have no such power. They just pursue their economic interest. And ecological crisis is a result of all decisions of all individuals combined together. But I think this claim is wrong, because we know that even though each individual has no such power, they together as a group hold the political power that could be used to make difference in terms of the world condition. And since, like in the democratic country, they all share equal power. So we know that a group can dominate someone. In this case, one generation is a group in that sense. And this group generation, today adults, are dominating children of the next generation. So I think to emancipate people from the view, I mean, to preserve freedom for people in the future, it's necessary for political society to implement the right to a non-spoilage world. It's like people today, the right say that people today can do economic development, they can enjoy utilities from the nature, but their children, when they become adult, they should have exactly the same opportunity. If they have less than that, it means that people of today have the power to dominate them. So to preserve freedom, we need to preserve such right. And I think there are some objection to this. This is quite technical. I will not go through all of them in details, but I'm happy to discuss about this after the presentation. First of all, some might say that my argument so far can only ask the current generation to protect the world for people of the next generation who were already born. Let's say that A has the duty to protect the world for B, but it didn't ask the current generation A to protect the world in the very long run for people who were not born yet. Let's call them C. That's because C haven't born yet. So we cannot charge that A is dominating. The action of A today is merely the selection of identities of people in the future, like the non-identity argument already said that, but my response is that if A decides to create negative impact in the very long run, for example, they might preserve for example, they use the resource of the very long future during C time now, so we will have the same world condition as A, but C will not in the future. In that case, I argue that A is dominating B, because when the time that B become adults, when B become adult, they will realize that in the near future, in the time of their children C, the world gonna be worse than the world that they were born into. So according to the right to an unspoiled world, they have the duty to rectify such situation. And since this bad world condition is the result of A action in the past, it means that now is determining B action during that time, and A is dominating B. Just for acknowledgement, there are two limitations on my arguments. First of all, my argument doesn't ask the current generation to improve the world condition in the case that they already were born into, if their parents worsen the world and they're born into that condition, they have no duty to improve it. They just have the duty to pass that condition, not to make it worse. Just pass that world condition to their children. And second, my argument doesn't take into account the fact that the number of population increasing over time. This is a technical objection, but none of them overall doesn't change the fact that my argument here at least could ask we today to rectify the ecological crisis that caused in our time. So with the justification for private property and justification for the right to a non-spoilage world, combining them together, I think what we can conclude from them is that we need to preserve the world in the sense I already elaborate by maintaining the institution of private property, and we can do that by focusing in the details, like the detailed structure of the private property. As Stuart said before, there are many bundle of rights under the label of private property, and we can adjust them in detail. Like we can put some regulation, prohibition on the right to exchange. We can prohibit the activities that are going to lead to negative externalities in the long run. And the Republican freedom concept also offers some more analysis. It said that this kind of adjustment should take form of regulation or prohibition. It could not take form of incentive. For example, if the government say that they're going to cut tax for some people who contribute to the world, that is not enough for the Republican concept of freedom, because incentive mechanism is a refutable reward. Those who were targeted by the incentive can reject the incentive according to their view. And that is not enough for Republican concept. As said, freedom shouldn't rely on the view of people, but guarantee robustly. So incentive mechanism is not enough, but we need some kind of regulation or prohibition on the negative externality. And second, we have to establish that this kind of right in the level of constitution, because unless the right to an unspoiled world will relies on the democratic will of people today, which again fail the Republican standard. I mean, there are some technical details on how to constitutionalize the right like this, because some might say that managing environment is a matter of policy and you cannot put it in the constitution like that. But at least I think we can say in the level of constitution as an expressive value that command people today to preserve the world condition for the next generation and like create some institution to enforce it, and let that institution work on the level of policies on how to preserve the world. I think that all I have today. Thank you.
So thank you, Tawan. Are there any questions? So we start with the room as before, and if you're online, please raise your hand or use the chat. So yeah.
Thank you for the presentation. I was just wondering why you thought that we needed the Republican idea of freedom to get the conclusion that you came to.
Speak louder.
Louder. I was just wondering why you thought we needed this kind of quite thick Republican concept of freedom in order to get to the conclusion you do, because I mean, I'm thinking here that I noticed there's a few papers recently about socialist republicanism. So the idea, I can very much see how if you want to get to this conclusion about democratic public ownership of the means of production, then having this like very thick concept of freedom is going to aid you to do that. But if your conclusion, at least from what I understood, was just kind of, you know, we need to kind of constitutionalize some sort of just savings principle, we need to have some sort of regulations and some constraints, isn't that just kind of, I mean, what distinguishes that from like a kind of, some would say, less controversial kind of liberal egalitarian idea of freedom? Yeah, that was the question.
All right, thank you. That's great. I mean, basically, I have no problem with the idea of egalitarian justice, like the argument from them to preserve the world. I mean, I have no position on that at all. But what I'm trying to do is like, I mean, when someone, for example, use the egalitarian argument like that, asking for green reform, many people gonna raise the concern of freedom, like it's like a normative war, like standing against, like you have to fight between freedom and egalitarian arguments. And what I'm trying to do is like, I would like to destroy this normative claim of freedom. I would like to like steal it back to the, like shift it to a more green position.
Yeah, I mean, that makes sense, but then sorry, I'll just follow up really quickly, but that makes sense, but then wouldn't the sort of non-interference liberal freedom person just say you were like begging the question by just kind of incorporating your own much thicker concept of freedom? But I can see how that would work if you were using the concept of freedom that they would have, but I don't see how you then get around their concern unless they buy into the Republican concept, which it seems like they won't. Does that make sense?
That does make sense. I mean, yeah, I would bite the bullet on that. I mean, you can consider my argument here as like a supplementation to egalitarian justice, or I mean, but yes, generally you're right. We're gonna buy this argument only if we commit to the Republican concept of freedom. But I mean, why not? Right?
No, that's helpful. Yeah, just trying to get clear about mistakes.
Yeah, but thank you for that question. And also, I mean, my attempt here, I mean, in the full paper, I also discuss about the idea of socialist republicanism. But I do have this argument because I don't want to jump to the idea of like common ownership over all productive resources. This is a less radical argument than that, but I think can achieve the same result in terms of green arguments.
Thank you.
Okay, so I think we can move to online questions. So first, Kalpia, and then Nikas Angelboer. Maybe we can take both questions and then you can answer them. So,
yeah, hello, thank you. A very interesting talk again. My question goes into a similar direction as the previous question, and it's about the concept of Republican in here. So what is the importance of calling this Republican, and what are the implications of choosing the term Republican. So it's just about this term, not about the concept of liberty or freedom that you've been talking about, but just about calling it Republican. Thank you.
Niklas, so you can answer those questions afterwards.
Yes, thank you. I hope you can hear me.
Yeah.
First of all, thank you very much for the interesting talk and also for this very timely and important conference. I also want to go to a similar direction as the first question. I see that the Republican conception of freedom is a sufficient condition for the kind of argument that you want to make, but I wonder whether it's a necessary condition, just as the first question was. And the reason why I highly doubt it is that in Germany, we actually had a hugely influential ruling a few weeks ago of the federal court. I'm not sure whether you're aware of it. And I wanted to bring that to your attention because it's really exactly the kind of argument that you're making, but from a very liberal perspective. So very briefly, the case was there was a German Climate Protection Act, which the government launched to reduce carbon emissions to until 2030 to a certain extent. And young people went to the court and said, like, if we do it like that, then our liberty, our negative liberty, is highly reduced, because by 2030 we will have to have such, or after 2030 we will have to have such drastic measures to keep the carbon emissions down to the level that we are signed to do according to the Paris agreements, that our freedom, our negative freedom, will be impaired. And the ruling of the highest German court actually said, yes, you're right. They used a term which translates into English roughly something like, this would be an advanced interference-like effect. So you're interfering with the future freedom of people. And so I do wonder whether you can actually get the same argument that you were making out of the idea of negative conception of liberty as non-interference if you introduce that kind of thinking into it. If you're interested, I can send into the chat a quick summary in English of this decision, which is really interesting, I think.
All right, thank you. The first question regarding the term, they got the term. I mean, the term Republican come from the fact that this idea of freedom is based on the paradigm of free person during the time of Roman Republic. I mean, some historians or some theorists work out on the idea of Roman people, and they build up this concept of freedom based on that. So they call the term Roman Republican to call this concept of freedom. That is where the name comes from. And regarding the court case, and thank you very much, I would appreciate to have it. Yes, we can arrive at the same green conclusion if we commit to the negative concept of freedom. But I mean, the reason is still different. If you talk about negative freedom, it's going to be about like freedom of, like, if you protect environment today, you're going to be able to protect freedom for people in the future, right? Something like that. Like the benefit outweighs the loss today. I mean, more freedom. We're going to have more freedom overall if we protect the environment. But in that last argument, you can still see like some kind of trade-off between freedom of people today and freedom of in the future, and we need to figure out on the empirical basis which one going to maximize freedom overall. But if we commit to the Republican concept of freedom, there is no such trade-off. I mean, preserving the world is compulsory. We don't have to like work on the empirical debate on how to maximize choices of people, something like that. But still, yes, if people don't buy the Republican concept of freedom, we don't buy this argument, of course. Yeah, and I mean, I have no argument for that yet. Like, which one is the correct concept of freedom at the moment? Something like that. It's beyond my, I mean, my paper right now.
Okay, maybe. Okay, I see we also have a question from Charlie Richards. So please, Charlie, and Maybe afterwards, I also have a quick comment, and then afterwards, well, if someone still wants to raise a question very quickly, so we join a last.
Oh no, sorry, I was just scratching.
No, sorry. So Charlie, then I have a comment, and then we can answer all the questions.
Brilliant. Well, thank you very much. I really enjoyed the paper. I think it's really interesting. I just had a question around the part of your paper that's the Republican justification of private property. So you give two reasons. One, that private property can monopolization, which you see as a form of domination. And also it can create conditions of prosperity, which supposedly enable us to save people from destitution. It can also be a form of domination in your view. But it seems to me that for the Republican case for private property to work, they can't just be pro tanto considerations in favour of private property, but they need to be something like things considered justifications of private property. So a Republican, more radical Republican might say, okay, given certain assumptions about the economic requirements of efficiency or how markets in like general equilibrium work to offset monopolies, we can say that these are two kinds of domination that private property might stave off, that markets might stave off, right? But then they might say that private property as an institution constitutes other forms of domination, maybe in the workplace, maybe in the home, and that actually, as an all things considered Republican justification, more interventionist forms of economic ownership and governance might have to be instituted, right? So that maybe, you know, we shouldn't care so much about monopolies, for instance. We should care more about the relationship between husband and wife, parents and children. So I suppose my question to you is, what would you say to maybe a more radical Republican that would say, well, you've given us two pro tanto reasons in favour of adopting private property if we're Republicans, but what you really need to give me is an all things considered justification for why private property outcompetes other kind of conceptions of Republican domination, or can speak to that a little bit. So I'd be interested to hear your thoughts on how you sort of navigate that question.
Thank you very much for the question, Charlie. Actually, that is the topic I'm working on in my PhD dissertation. Basically, I would say that yes, the regime of private property could lead to another form of domination as well overall. But like you said, the domination in workplace between boss and laborers and like employers, something like that. But I think all of them, at least, I mean, could be mitigated or like solved by government intervention, like to put some regulation on them, you know, like to stop boss from bullying employees, something like that. At the end, I mean, there might be some form of ownership, like the socialist Republican try to advocate for the joint ownership regime. That might absolutely resolve the problem like workplace domination or maybe market monopoly as well, but they also come with another form of domination as well, which I think is more severe. If we allow the state to control the market, they're gonna have the problem of, I mean, that is a very clear case of monopoly, and the state gonna have absolute power, very absolute power, which I think is the case of domination that we really want to avoid. And given that as a presumption, we don't want the state domination, and on the other hand, we can have the rule of joint ownership. But to be honest, I don't have a complete argument against it yet. But I quite follow G.A. Cohen in some of his discussion that one major concern of this kind of rule is that it's going to lead to the problem of ineffective ownership. Like you have to share everything with all other people. We have to queue when we are going to use something, and I think there are going to be many forms of domination that could arise in that context of relationship. So overall, I think it's a good idea to start to work on the idea of private property and try to resolve the undesirable outcomes of it. But my argument overall again doesn't reject the idea like you can have some level of common ownership, some level of public ownership in the overall regime of commercial society as well. I mean, everything is fine, but just that at the end, it leads to the maximization of freedom as non-domination in this sense. I'm not sure is that answering your answer, your question.
Well, thanks for the answer. Okay, well, Charlie seems to be happy about it. So good. I will retain my question. I think we deserve a break. So, well, we're going to reconvene at 11 here in Britain, and so this will be noon in France. So in 25 minutes. In the meantime, please stay connected, so we don't have to re-unmute you, through the lobby and stuff like that. So you can just turn your camera off, your microphone off, and we reconvene in 25 minutes. Well, thanks.
What was the name you just mentioned at the end that you said that someone had read?
Coherent.
We have coffee over there.
Oh, Joshua.
I don't know. I know he supports. Yeah.
Thanks. I think you can let the camera on. So
Sure, yeah.
And I will try to come back occasionally to see even.
Oh no, of course, yeah. I'm just interested in that as an example of securing and stuff.
All right.
Especially when it comes from quite technical.
I think the keyword is like ineffective self-ownership.